Let's bring in our trial attorneys that are standing by. Michael Jaafar in Detroit and Washington, D.C. Law enforcement and litigation expert Sonny Slaughter. Thank you both for being on today. Michael, we're hearing that this victim, Kyle Hill, beat up his grandmother. I mean, even if a judge allows this to go through to a trial, do you think a jury would convict this woman of what happened in 2018?
If the evidence is submitted as we've heard today, and if it's allowed to be submitted to a jury, I can't see how there isn't reasonable doubt on this. Again, this is assuming that the court allows all this evidence to come in. But when we were in law school, professors would give us exams, and they would craft these elaborate fact patterns, and it would always be right down the middle in order to see how creative you were as an attorney, as a student, to analyze the fact patterns. They would never give you fact patterns like this, right? Because this fact pattern is very one-sided in favor of, this is self-defense. So, but the prosecution is poking some nice holes in it. She never called the police, she called her friend. But to answer your question, yes, if the evidence that we've heard today is allowed to be submitted, I don't see how a jury is not going to acquit her on self-defense. It does seem very unlikely to me.
All right, let's bring into the discussion our trial attorneys that are standing by. Michael Jaafar in Detroit and in Washington, D.C., law enforcement and litigation expert Sonny Slaughter. Michael, we're going to hear those text messages in a moment, but your take on not only how the victim's mom is doing on the stand, but also that moment about these text messages.
So here's my analysis of this. I feel like there's a reason why the prosecution decided not to bring this case, and then they changed their mind. I feel like after they decided when they decided to bring the charges, they started hearing more and more evidence. Now we know it's from the mother, right? Another side of the story to who her son was. These text messages are going to be revealing. And also what I'll tell the viewers is these stand your ground hearings are not a trial. That's why you saw the defendant testify, because she's actually required to testify, right? In Kansas, she's actually required to testify at the stand your ground hearing, right? So that's why this looks like kind of like a TV trial. It's not a real trial, but because it's a stand your ground hearing. So the way I see it is these prosecutors started finding evidence about this incident after they decided not to bring the charges, and it seems to me like the evidence was brought to them by the mother. I think she's performing as best as she could. She lost her son. Like my co-panelist says, you know what your children are capable of. She clearly is capable, knows who her son was, but she wasn't happy losing him. She may have even warned him, hey, you need to cool your jets because you're going down a bad path. But I think this is going to be telling, and what these text messages show are going to basically be the deciding factor on whether or not this case goes forward.
As we get into more of this case that is set to have opening statements on Wednesday, let's bring in to discuss our experts who are standing by. Trial attorney Michael Jaafar in Detroit and in Washington, D.C., law enforcement and litigation expert Sonny Slaughter. Thanks to you both for following along. We're shifting gears to this Nevada case. Michael, I want to ask you about the prior bad acts side of this. I mean, it's extensive. You heard that story from Julie, where we have a defendant whose prior accusation of killing his second wife, Becky, in Utah, that came into this Nevada case when he's accused of killing not only the hitman that he hired, who then killed his wife. He was convicted by a jury, but that was overturned by the higher court. Can you explain the problems and the dangers with bringing in prior bad acts, even when it seems like if he was accused of killing the second wife, then certainly it should be brought in for the death of his sixth wife?
It's black letter law in our country to not allow people to introduce prior bad acts into a trial when you are, defending, for your life and for your freedom, right? Had he been convicted of that prior case, it would have been different. But it may not have been different, but it might have been different. But he was acquitted of the prior accusation. And so, again, when you on camera, he looks like a creep, right? People looking at him will look at him and say, this guy looks like a bad actor. He's got the life insurance proceeds. He clearly seems like he had a hand in his wife's murder, right? That's what you see when you see him. But the law has to be blind, right? We have to create a law for an entire society, not just for a specific person. And for a whole entire society, we've just decided that we cannot allow, if you are defending yourself, if you are accused of a crime, for the jury to hear of the other times that you were accused of a crime, even if it's similar, right? And so, you know, it's really to protect the system, to protect the society. And so I was shocked that the Supreme Court overruled it. It's very rare to see a criminal conviction overturned on appeal. Very rare, right? This is one of the very few times when you see it. But I think the law has to be blind. It has to basically just, insist on its own institution, and it's a black letter institution to not allow the introduction of prior bad acts into the accusation of the current crime that you were defending yourself for. So, I kind of feel like they did the right thing by overturning it, even though this guy is clearly a villain.
You're right. It's a rare thing for the high court to overturn a case like this. I want to bring in very quickly my two guests, Michael Jaafar in Detroit and in Washington, D.C., litigation expert Sonny Slaughter. I just want to ask you, Michael, first, do you think that the judge will allow in that walkthrough video?
I think she has to, because he volunteered the information. There's no evidence that he was promised anything or threatened if he didn't do the walkthrough. I think the probative value of this far outweighs any type of prejudice. I mean, he's defending. He's saying he didn't do it, and he's defending himself. So I think the judge is going to allow it. And I feel sorry for the judge, because she's sitting in a case now where it was overturned by the Supreme Court because of the actions of the court in the original trial. So she got her work cut out for her.
I'm sorry, we have reached the top of the hour, and Sonny, I hate that I can't get to you.